Hi, good afternoon. My name is Michelle McDonald, and I'm an attorney with Merhab Robinson and Clarkson. Obviously not Paula. So I'm here today to talk to you guys about who's the boss and choosing the right trustee for your trust. Okay, here's a little bit of background about myself. I am just a moment. Um, so I'm an attorney here. I went to school in Arizona. I originally grew up in Tustin, but went to school at University of Arizona for my undergrad, studied finance and Japanese, but always knew I wanted to become a lawyer and went to college at ASU, but always consider myself to be a wildcat. So, what is a trust? A lot of you here probably already have a trust of your own, or you're thinking about getting a trust. A trust is an estate planning tool that people use to make decisions, not only for what's going to happen on their passing when they die, but also on how your finances and your accounts will be managed if you become incapacitated. So, a trust is an agreement between a trust maker and a trustee. The trust maker is the person who to decide on the terms of the trust and who's going to be in charge of the trust, how all of the asset things will be managed. The trust maker can put all those into the trust, and then the trustee is the one who's going to carry out those duties. So the trustee manages accounts and property for the benefit of the beneficiaries. And you can make it as specific and as customized as you like. If you're the initial trust maker and trustee, then usually you will just manage your assets and go about your daily business as you usually do. You may not pay too careful attention to the exact terms because all of the assets are yours and it's just considered you. But if you're appointing somebody else to be your trustee, it's going to be very important that that trustee is following your specific terms of your trust and carrying out the duties exactly under the terms of the trust and the California Probate Code. So it's really important to pick the right person to be your trustee to make sure that they're going to carry out those duties properly. So your trust can take effect immediately. Typically, when somebody creates a trust, it will be effective immediately. But you can also have one that's going to be effective if you become incapacitated, or it can be within your will or something that becomes effective on death. And it can be revocable or irrevocable depending on your planning goals. So usually during people's lifetime, they're going to create a revocable trust, especially if you're holding real property, and people will have a trust that way. An irrevocable trust has different planning goals. Sometimes if there's somebody who has special needs or they're getting government assistance, or if there's different tax concerns, there might be different reasons why you might want to create an irrevocable trust. Okay, going back to the trustee. So, what is a trustee? A trustee is the decision maker who's going to handle all matters related to your trust. So, if you create a trust, one of the first things that you're going to do is transfer your assets into your trust. And so your assets will not be in your name individually. They're going to be in your name as trustee of your trust. And then all of those assets would be managed by that decision maker. It's different than if something is in your own name and you had a power of attorney, which you're probably familiar with. Somebody may be able to act and make decisions for you in your name individually using a power of attorney. But the trustee is the one who's going to make decisions handling the assets in the trust. So it depends asset is titled. Depending on the type of trust, you may serve as the initial trustee. So that's typically what happens when a person creates a trust in their life. They're going to create a grantor trust. They're going to be the trust maker and decide all the terms that they want to have in the trust. And then they're also going to be the initial trustee who manages all the assets and all the day-to-day. Be your trustee at the onset as your initial trustee, and they can act immediately, or you can say that your trustee will only act if you're unable to act because of incapacity or death. And the trustee will then carry out the instructions that you have provided in your trust agreement. So you can be as specific as you want. Let's say you're you're planning for your incapacity and you decide you want to live in a specific nursing home or care facility that you've already chosen. You can select that this is where you would prefer to be placed, and you can give your guidelines on you want to stay in your home and you want as long as possible and you want caregivers to come there. You can put all of these types of agreements and decisions into your trust. So the right trustee choice is going to depend on the type of trust that you have, the assets, so the type of asset, but also the value of the assets. And then it will also depend on your family situation. So if you are a blended family, may make different trustee decisions than if you're a married couple and you were sharing the same children and you knew who you wanted to be in charge. So sometimes if it's a blended family, there's going to be a different selection for trustee. You might want one person from each side of the family to be serving jointly. You might want to have somebody who's neutral, but all of those types of things will be considered when you're selecting who you want to be your trustee. Sorry, next. Okay. Types of trustees. So as we discussed, you can have a trustee who acts immediately. That's your initial trustee as soon as you sign the trust document. And then there's also a successor trustee who would come in if the first person can't serve. So typically when you create a grantor trust, so the first trust that you're creating during your lifetime to hold your assets, usually the person who creates the trust is going to be the first trustee. So they'll be the initial trustee and manage all the assets. And then you'll select people or private professional fiduciaries or family members to be your successor trustee, and they would step in if you're unable or unwilling to serve, so on your incapacity or on your death. You can also be really specific with what you want that trustee to have control of and which assets. So you can have your trustee be control of everything that's in your trust, or sometimes when people pass away, they might have their trust split into subtrusts. And let's say you have your trust split into 3 subtrusts for your children. Well, you could nominate a different successor trustee for each of the 3 subtrusts for your children. It doesn't have to be the same person. You can also nominate somebody to be a distribution trustee. So you could say, I want this person to be in charge of distributing all of my tangible person property. Or you can say, I want this person to be responsible for selling the house and distributing these payments to the beneficiaries. And then you could even select and have a different person be the one who is your investment trustee. So maybe you have somebody who's really great financial advisor and has been making really good investment decisions, and you want that person to be in charge of the management and growth of your assets. You can appoint different successor trustees for different roles. Okay, next we are going to talk a little bit about the trustee duties. So this is a really important part of being a trustee. When you agree to become a successor trustee, you agree to not only carry out the terms of the trust, but you also have many duties under the probate code, and you're going to owe a fiduciary duty to the beneficiaries of the trust. So one of the things that I do at my firm is a lot of trust administration. So what happens when somebody who creates a trust becomes incapacitated and can no longer manage the finances, or if the person dies and then the successor trustee is going to step in and carry out the terms of the trust. So one of the things I do is to help the successor trustees understand what their role is, what their duties are, and how they can carry out the terms of the trust according to the plan and make sure that they're meeting their fiduciary duty. So sometimes if people are not communicating well, or they don't really know exactly how they're supposed to be managing the properties, and there's a little bit of distrust amongst the beneficiaries, that's where we might run into problems because people think there's some kind of funny business going on, or the trustees aren't distributing the property properly, or they're not investing it how they wanted to. So it's very important that the trustee is very well organized and understands what their duties are so they can do everything properly. So the trustee's primary duty is to manage the accounts and the property. So they have a duty to manage all the assets in the trust, and they want to make it productive. So it's not going to be a good idea if the trustee has all their money just sitting in a checking account that's not earning any interest. They should have it invested as a reasonable person would. So they need to manage the finances and all of the assets in a reasonable way. And they don't have to do it on their own. And they're allowed to get advice of professionals. So they can have a financial advisor. They can have, property manager to help with rental properties. They can get help and to make the trust property be more productive. So they will manage the investment accounts, real estate, and any assets that are held in the trust. They have to act in the best interest of the beneficiaries at all times. So it's really important that a trustee is going to treat all the beneficiaries equally. So you can't show any kind of preference to one person over the other when they're equal beneficiaries, and also to make sure that the trustee is not having any personal conflict. So if the trustee is going to sell a house that's held in the trust and they think, oh, my child's been looking for a house, maybe I'm going to sell it to them. Well, we have to make sure that it's going to be like a fair, reasonable transaction. And so under the terms of the trust, that may not be something that they can do. They have to always be acting in the best interest of the beneficiaries and always trying to get the highest possible price for things that they're selling. And so everything needs to be like very fair and very transparent, and the trustee needs to make sure that they don't have any conflict of interest. The goal is to protect and grow trust assets according to the trust's instructions. So protecting trust assets by making sure that things are invested reasonably, weighing up the risk and reward, and making sure that you're going to grow the trust assets in order to carry out the terms. So if the goal is to provide health care and maintenance and support for the person who created the trust, well, you're going to want to make sure that you're growing and you're using those assets to provide for that person during their lifetime. So making reasonable decisions like we would do for ourselves in planning for retirement and planning for healthcare in the future, that's what the trustee is going to need to do under the terms of the trust. Keeping beneficiaries informed is one of the most important ways to try to avoid conflict in the future. So transparency is key. And under the California Probate Code, beneficiaries are entitled to reasonable information on trust administration. So the trustees are going to be acting in their best interest on their behalf, and the beneficiaries are allowed and entitled to information on what. So the trustee may be required to periodically report to the beneficiaries and give them an update and tell them this is what's in the accounts and these are what the assets are and this is the expenses that we had this month or this quarter. And the trust can dictate exactly how the trustee is going to report to the beneficiary, or it can be under California law and the probate code. But keeping the beneficiaries informed is going to alleviate, some conflict in the future if the beneficiary thinks that something hasn't been done quite right. I want to make sure that we're keeping them informed of what's going on in the trust. The trustee needs to account for all of the income received and all of the expenses paid. So everything that's coming in and out, it's best not to use cash and to have everything by check and accounted for on what exactly is in and out. And the beneficiaries we discussed have a legal right to be kept informed. And Having transparent communication between the trustee and the beneficiaries, it not only prevents disputes, but it also builds trust within the parties. So the beneficiaries can see what the trustees are doing, see that they're making the trust property productive, and see, that everything has been accounted for, all of the ins and outs, and also to know exactly what the trustee is taking in compensation, and that they think that that trustee compensation is fair, is also going to help build trust. So a lot of times in a trust, it doesn't say exactly what the trustee is entitled to for compensation. It will just say something like they're entitled to fair and reasonable compensation. Usually that is a percentage of the trust assets annually. But that's one point where if a beneficiary starts to think that the trustee is taking too much compensation, then they might start to lose their trust in the trustee and start to question, well, if they're doing that, what else is going on in the trust that I don't know about? So we want to make sure that the trustees are going to keep really great records and provide that periodic report to the beneficiaries and just keep them informed of what's going on. A trustee is also going to act as the point person to answer the beneficiary's questions about the trust, and they're going to file all the required tax returns for the trust. If there's a lawsuit that's involving any assets in the trust, then the trustee would be the person who initiates that lawsuit. The trustee would also coordinate with professionals such as attorneys, accountants, and financial advisors. So, like we discussed earlier, the trustee doesn't have to have all the answers themselves. They don't have to know how to do everything. They can get help from professionals. So they can hire accountants to prepare that trust tax return. They can hire financial advisors to give advice on the planning and how to, care for the beneficiaries for however long the trust is going to go on. And then they can hire attorneys, such as our firm, to help guide them in understanding exactly what the trust says and what the trustee is required to do under the probate code. So if any of you have your own trust, you've probably seen it can be a really thick document, sometimes quite big. It's got a lot of terms in there. And so getting help when a trustee needs it is something that they're usually allowed to do under the terms of the trust, and that they should do to make sure that they're doing everything properly. The trustee is the central contact for all trust-related matters. So the trustee is in charge of everything that's in the trust, and they're the one who is going to be the one who should know what's going on with everything. Okay, what to look for in a trustee? So who should you choose when you're creating your estate plan? Who should you choose to be your trustee, and what's going to be the right fit for you? So one of the things to remember is that when you create a trust, you're typically going to be creating a revocable trust, which means that you can change who your trustee is. And so if during your lifetime, not only, change who you're close to or who you want to be in charge, but also looking to choose for the next generation. So when you first create a trust, you might be choosing, a parent or a sibling. And then as time goes on, maybe your kids grow up or people move away, you're going to choose somebody else of the next generation, or even a private professional fiduciary. Okay. So we kind of talked a little bit about this already, ability to ask for help. So trustees, the person that you're choosing to be your trustee doesn't have to be an expert. You don't have to pick a professional fiduciary or a CPA or attorney or somebody who does this every day. That's not who you need to choose to be a trustee. You just need to pick somebody who is going to know that they need to ask for help when they need it, and somebody who is organized and who's going to work hard to carry out the terms of the trust according to its terms. So financial advisors, CPAs, and attorneys can provide support, but are not usually the ones who are selected unless they're family members. But people don't usually choose their own attorney or CPA. Professional fees are paid by the trust, not the trustee personally. So if the trustee does hire an accountant to prepare their tax return, that's going to get paid from the trust funds, not from the trustees, not personally liable for any of the debts and the payment expenses of the trust. And the trustee should seek guidance, and it's actually a sign of good judgment and not weakness. And the trustee can build a team to help them administer the trust to help make things go smoothly. So this is one of the most important characteristic traits of a trustee is to be detail-oriented and organized. If any of you have served as trustee of a trust before, then you'll know that it can often be a lot of work and you have to manage a lot of where all the assets are, figuring out who the beneficiaries are, making sure everything's paid on time. I'm sure you all, think about the daily house admin that we each do in our own homes, and then think about when you're trustee, you're now doing that for another person. So all of the day-to-day kind of house admin of expenses and bills and managing everything is what the trustee is going to be doing under the terms of the trust. So the trustee should be detail oriented. They've got to follow the probate code, and there are certain rules and things that they're going to have to do depending on the situation. If somebody becomes incapacitated and a trustee is stepping in because the elder person is no longer able to manage their finances, then there's going to be a certain set of rules and a certain, notices and things that they have to do under the probate code and the trust. And if you don't do those things as trustee, it opens you up to liability from the beneficiaries. So one of the reasons why we talk about how important it is for trustees to make sure they're doing everything properly is because a trustee can be personally liable for a breach of their fiduciary duties. And we want to make sure that the trustee is not opening themselves up to some kind of a complaint and claim from a beneficiary. So sending out the required notices and taking these specific legal steps that are required are really important. The trustee needs to compile an accurate inventory of all trust assets. So when the trustee steps into their role, they're going to inventory everything and account for all of the assets that are in the trust. So this is an investigation period. Sometimes it can be really hard to find out exactly what's in the trust because people don't get mail. And so you're investigating and figuring out where do they have accounts and what did I know about, or, trying to find out from email and figuring out what all is in this trust. Sometimes we've hired personal investigator to go out there and search because people know there was some account over here that the bank's changed names or they can't find it. And so the trustee needs to make sure that they have an accurate inventory so that they can actually control all the assets and make them productive and distribute under the terms of the trust. The income and expenses have to be carefully tracked and documented. So the beneficiaries of a trust are entitled to reasonable information, and they could also be able to demand an accounting. They're entitled to some periodic reporting. And so we want to make sure that the trustee is keeping really great records and that they're able to provide these records and accountings to the beneficiaries when required. If you're having sloppy record keeping and you're having money that's gone out of the accounts that can't be tracked and is now unknown how it was spent or how it was used, that's where we're going to run into some beneficiary disputes and potential legal action. So the trustee needs to make sure that they are really tracking all the ins and outs, and so they don't have a beneficiary who's going to be making a complaint against them and possible petition to the court. And being precise is going to protect everybody. We want to avoid any unnecessary legal fees, any unnecessary complaints from people. And so being detail oriented and having good record keeping is really important. Okay, being organized. So depending on the trust, There's going to be different assets in there. Sometimes it could be very complicated what assets are in there. It's not always just going to be a brokerage account or a bank account. Sometimes it's a partial ownership interest in a business, or it's a percentage of something. There could be multiple beneficiaries that you're having to distribute to, and they could be getting different amounts, or the terms of the distribution are different. All of the trusts are unique and different. And so the trustee's duties are going to vary depending on what the terms of the trust are. If it's a really complicated trust, then there's going to be a lot of moving parts, and it's obviously going to be a little bit more work for the trustee. If there's one brokerage account, one bank account, maybe the house, then that might be a little bit simpler for the person to manage. It all depends. So being organized is really important. This second one is also super important. Trustee has to keep the trust affairs completely separate from personal finances. So never commingle. Never take something and put it into your account, and then you're going to transfer it in, or receive rental income to your own and then you transfer it over to the trust. No, we want to avoid any commingling of trust assets with personal assets. And if the trustee does commingle, then it could open them up to having their own personal assets being involved in some kind of litigation. So we want to really avoid that. Distribution plans require careful coordination over time. So every trust is going to be different. Sometimes a trust is going to say that on the death of the creator, it's just going to go outright to the beneficiary. And that's going to be a lot simpler, just a distribution, the trust will dissolve. But sometimes the trust is going to actually split and create a subtrust. And so if a subtrust is created, then that actually means that the trustee is going to stay on as trustee for whatever the terms of the trust are. So it could mean that they're staying on as trustee until a minor child becomes 30 years old, or it could mean that they're staying on as trustee for the lifetime of the spouse who's now living in the house. It all depends on the terms of the trust. So it's really important that the trustee understands the distribution terms of the trust so that they can understand how they need to plan, how they're making distributions, and what the goals are of the entire trust to make sure they're doing it properly. Good organization is going to prevent costly and embarrassing mistakes. So it's just really important to stay organized. And an organized trustee is going to earn the confidence and the gratitude of beneficiaries. So if the trustee is providing these periodic reports to the beneficiaries without them asking, and the trustee is providing, statements or tax return or whatever it is, but really communicating, then it's going to go a long way in having that beneficiary's confidence. And okay, being a good communicator is also really important for the trustee. They've got to act in the best interest of the beneficiaries. And so transparency, we keep talking about, is really important. Keeping the beneficiaries informed of their decisions. Let's say that there is property in the trust that's no longer being productive, or it's fallen a little bit into disrepair and the maintenance work is too great, so they decide to sell it. Keeping beneficiaries informed of the actions or big decisions like that can also help go a long way with gaining their trust and confidence. Also, responding in a timely manner to their questions. And so trustees may reach out, or beneficiaries may reach out directly to the trustee with questions on something that's going on. So just making sure that the trustee is going to get back to them in a timely manner. And also this one, choosing somebody who's able to work with or get along with the beneficiaries. So that's something that people also need to be aware of. If you're thinking of having a trustee that maybe doesn't have a great relationship with one of the beneficiaries, or even if they do have a great relationship, if you're choosing a trustee that's going to be in charge of their subtrust, and now the trustee gets to decide if you're getting a distribution to pay for something, or if they're going to pay for this maintenance request or support. It could cause some friction in the relationship if the trustee doesn't think that that's the right decision under the trust. So you have your beneficiary who's demanding that you pay for this vacation because they always go on this vacation every year and it's a part of their maintenance and support. And then you have the trustee saying, I don't think that's right under the terms of the trust and not wanting to pay it. Well, it could cause some friction in that relationship. So it's something to also think about when you're choosing who is going to be trustee of a trust and who's going to have control and be the one to decide what gets distributed. You just want to make sure that it's not going to cause like family problems or that the relationships won't really be in detriment. So that's something else to think about. Poor communication is one of the leading causes of trust disputes. So if people are not communicating properly about what's happening in the trust, sometimes then the beneficiary may take that as the trustee's hiding something. So if the beneficiary is asking the trustee a question about something and the trustee's taking a long time to respond, or they're being vague, or then when they respond, they only give a half answer, that starts to cause distrust. And the beneficiary is thinking, why aren't they telling me this? Is there something else going on? So it's really important to be transparent, and the beneficiaries, again, are entitled to reasonable information. So making sure that the trustee is going to communicate with them and provide that is also going to, cause less disputes. And one of the reasons that we're always also really concerned about avoiding trust disputes, we don't want to get involved with the court and litigation, is that it can be very costly and it's very emotionally draining and it's going to damage the relationship. So if you're picking all family members who are involved, then we want to make sure that we're trying to avoid any friction and damage to the relationship and the families. Okay, picking a trustee who's willing to follow the rules is also important. There are a lot of rules and guidelines that they need to follow. There's state law, federal law, and the trust itself. The trust can be as customized and specific as you want it. And so there will be certain details that the trustee or the person who creates the trust maker can choose in their trust document that are different even from the federal state law. So the trustee needs to follow all those rules. Sometimes they have discretion. So that means that sometimes the trustee can choose what's distributed. So in that previous example of where the beneficiary is asking for money to go on a vacation, the terms of the trust might give the trustee discretion to say they will distribute that money. And it could be a choice and not always distributed. Whereas something like healthcare, maybe there's like less discretion because a healthcare medical bill is a medical bill. But when we're talking about distributing for somebody's maintenance and support, it's a defined term, and we think about our support of providing housing or providing for grocery bill and our kind of known needs that we have. But when it's a want, and then it's something that just falls into what's the lifestyle that you're accustomed to. And that's where there might be some more discretion from the trustee about what is your lifestyle you're accustomed to, and should I distribute for that? But a lot of times the trustee will have a very specific guideline and they just have to do exactly what the trust says. So it might say this person gets $60,000 a year and the trustee is going to distribute $60,000 a year. Okay, failing to comply can expose the trustee to civil or criminal liability. So the trustee has many duties under state law and federal law. And if they breach any of those duties, then yes, they can have civil or criminal liability. So it's really important then that the trustees understand what their duties are. They have the duty to carry out the terms of the trust, but they have all these other ones that we touched on a little bit about the duty to make trust property productive, the no conflict of interest with selling a property to themselves at a really low value, or Um, they have a lot of duties that they need to make sure they're following. The trustee's job is to carry out the trust, not rewrite it. So sometimes a trustees may see in the trust and they don't like the terms. Sometimes I've seen trusts where it provides for an outright distribution to someone that maybe is not the best at managing their finances or has had like a history of substance abuse problem and is probably not the person who's supposed to get like you would rather not give them an outright distribution. You'd rather help them by giving them, a monthly or a weekly distribution to kind of help them manage their finances. But it's not the trustee's job to decide what's better for that person. The trustee just needs to do what the trust says. And usually they can't change the trust if it's not their trust. But if they're a successor trustee, then they typically can't change the terms and they have to only carry out the terms. When in doubt, always consult an estate planning attorney. So sometimes the very thick trusts can be very wordy, a lot of legalese, and could be difficult for people to understand exactly what the terms are. And somebody who specializes in estate planning and trust administration is going to understand how to read the terms and be able to guide the trustee in knowing how to carry them out. So your trustee options. Okay, typically I'd say most of the trusts I see people choose family members. And it's usually a spouse, an adult child, a parent, or a sibling. And this just varies on who people will choose. They pick somebody that they think is going to be organized, that they think has the characteristics to really carry out the terms and pay attention to detail, and somebody who is maybe neutral amongst the family in choosing who they're going to select. And sometimes also somebody who lives near you if you wanted to have somebody who's helping you manage everything that lives closer by. But your trustee can live anywhere. And these days with online banking and the internet, it doesn't have to be somebody who lives near you. The family members usually have an intimate knowledge of your wishes and values. And so that helps them be trustee because they might have like a little understanding of what your goals were under the trust when you created it and how you want it to be carried out. Uh, if the trustee is also a beneficiary, they may choose to waive compensation. So usually a trust is going to say that the trustee is entitled to reasonable compensation. And because it's a lot of work, and sometimes I have trustees come in and they say, I'm not taking compensation. I'm going to waive it. And then it ends up being so much work. They're doing like for a very like a large trust or one that's just very complex and has a lot of moving parts and a house that needs all these renovations and these different accounts, then maybe they decide they are going to take some compensation just because they've been working so hard. One thing for trustees to remember is that compensation will be treated as income. And so sometimes they choose not to take it. They don't want to claim the income. And if they're also a beneficiary, they just inherit it that way. This one, caution for naming a beneficiary as trustee, reducing asset protection. So if you have a trust that you have separate subtrusts for, and in the very beginning, we said you can name a different trustee for each of your subtrusts. So if parents create a trust and they do subtrusts for each of their 3 kids, they can name each of their 3 kids to be trustee of their own subtrust. But you might lose a little bit of the asset protection part. And what that means is like if you're creating that trust to be irrevocable and to have some asset protection, if your child is in charge of their own share, there might be a question about, well, is it really irrevocable and is it really, asset protected when the child's controlling everything? They're distributing and they get to make the decisions on what gets distributed and what doesn't. So it's just kind of a caution to think about when you're choosing if you're going to name the beneficiary of the subtrust as their own trustee. There might be a little less asset protection. Choosing a family member is going to be best when the family relationships are strong and conflict is unlikely. Um, I think in general, when the families get along during people's lifetime, they generally are going to get along when they're dealing with all of the post-death administration. But if there's already been some like friction or something happening during the lifetime, then when you're dealing with all of this post-death administration and managing the assets of the trust, there's maybe going to be more likely that there will still be conflict later. So that's what you want to think about if you're going to choose a family member. Close friends, you can choose a close friend to be your successor trustee. And your close friend may also share your values and understand what it is that you want for your planning and your legacy goals. Um, they may be reluctant to get involved in family conflict. So I had this happen also recently. A close friend, best friend, was appointed as successor trustee, but it's a little bit of a complicated trust because of the different people who are beneficiaries and the different personalities. And so a close friend may not want to get involved in all of that kind of drama between the family members and the different people involved. And nobody has to serve as trustee. So just because you name somebody in your document doesn't mean that they have to serve. And so you want to make sure that you're choosing people who are going to be willing to serve. And it's also why you want to have alternates in place in case the first one, I mean, maybe that's not that they don't want to do it, but maybe they can't do it, that they have their own health issues or they have, something going on with their business or their own parents and they can't do it. So it's good to choose alternates and then make sure you have people who would be willing to step in. The close friend may not be a beneficiary of your trust. You might just have your family members as beneficiaries. And so entitled to compensation from the trust. And they might take that because they're not benefiting from an inheritance from the trust. Compensation can sometimes create friction with family beneficiaries. So if the compensation is just reasonable, and then the close friend tries to take some, like a really large percentage, 10% of the trust assets, something crazy. The other beneficiaries may have an issue with that, or the beneficiaries may think that the trustee, the close friend, didn't really do much, and they may think they don't deserve it because they didn't do a lot. So it could cause some friction if there's a disagreement about the compensation. You want to choose somebody who's going to be neutral and professional, even under pressure. So somebody who can help with the different personalities of the different beneficiaries and who's going to, treat everyone equal. You have a duty equally, and so they need to stay neutral. There are also professional trustees. So there's private professional fiduciaries or there are corporate fiduciaries. And this is a good option if you want to protect beneficiaries' inheritance, and that's like your top priority because these professionals are going to be really knowledgeable about making trust property productive, about following the guidelines in the trust and making sure that they're distributing everything as they should. One of the things to consider if you're going to hire a corporate fiduciary is that the corporation may have an asset limit. And so you need to make sure that the corporation that you're appointing, it is going to accept your trust because it'll depend if it's under a certain asset threshold, then they may be unwilling to serve as trustee. Professionals are going to have deep expertise in trust administration, taxation, and investments. They do this every day. It's their job. They're going to understand how to make everything productive and do it. They will charge a fee, and it's also usually a percentage of trust assets annually. There's no personal conflict because with the family beneficiaries. And we can help you to identify the right professional trustee for your situation. So depending on what the terms of your trust are and, if it's going to be ongoing with subtrusts or outright, or if your priority is also for incapacity planning, we can help you to identify a professional trustee. There are some professional trustees that will also meet with you if you're doing incapacity planning because you have a dementia diagnosis, but you're still, creating your estate plan and you're still your own decision maker. You can meet with the private professional and talk to them about your goals and your desires, and they will get to know you and what you want so that when you become unable to manage your own finances and you need a successor trustee to step in because you have dementia, then they'll have like a care plan kind of for you. And so there are some private professional trustees who will do that. Or they might have a free consultation if you wanted to meet people. But you can also just nominate somebody in your trust. Hey, so that's it for us. I'm going to open it up to questions. I think I might have something here. Um, okay, there's a question says, we have two adult children. What are the pros and cons of them being joint trustees versus naming all of one of them? So as general information, it's really hard to say without knowing their personalities and knowing their dynamic and everything. Sometimes people will choose two children to be their co-trustees because they don't want to pick one person over the other. But one of the issues that could come up is that when you're having two people as a co-trustee, who's your tiebreaker? So if they disagree on how something's going to be done and they they each feel very strongly about their opinion, even if it's like, keep the house, sell the house, use this bank, use that bank, but whatever if they disagree on, who's the ultimate decision maker? And so I think if you think about that question about who you really want in charge, that might tell you who you should have as your first one. But a lot of people will also pick their two children because their children get along fantastically and they know that there's not going to be any issue. And then they do serve as co-trustee and everything is really smooth and there's never a problem because they just get along so well. It is a specific question that's going to depend on your kids and what their relationship is. Sometimes what people will do if they want to have both their kids involved is they might think that one is better for their healthcare decisions. And then maybe they put one on healthcare and the other one is trustee. Um, but that's a specific question that would be discussed in an estate planning appointment, and they could talk about your specific kids. Any other questions? And so picking your successor trustee is um, really one of the most important things you can do. I know a lot of people think about planning as just what's going to happen with your assets on your death. But these days, with people living longer and the rise of dementia with people, it's also really important to be planning for potential incapacity and at some point needing help from your successor trustee to manage your assets while you're alive and during your lifetime. And everything is going to be for your benefit because you're incapacitated. So you want to make sure that you have the right successor trustee named and the right people in place who are going to carry out all the terms of your trust, all your wishes about where you want to live or what you want for your pets, where your pet's going to go, and all of your decisions that you can choose under your trust while you're incapacitated. You want to make sure that you have the right person in place to do that for you. So lots of things to think about here. I think with the trustee's duties under the probate code and the trust, and also what it is that you want from your trustee if you're incapacitated. Okay, I hope you found this helpful. Thank you for joining us. We have another webinar coming up next month. You can register for. It's going to be presented by my colleague Cassidy Russell, and it's on No Kids, No Problem, Estate Planning for the Child Free. So we'd love if you could join us for that. It's on September 16th, 2026, same time, same place here. And we will also be sending you through a video of today's presentation. And if you have any additional questions that you wanted to ask privately outside of this, you're welcome to contact me here. Again, my name is Michelle McDonald, and I'm an attorney here, and you can reach us at yeah, by phone or by email. Thank you very much for joining.